Good evening, Anannya. You are an
Good
alumni
evening.
from Amity University, and I'm your Universal's head of department in academics, and that is a publishing house, right?
Yeah, it's like Universal Lawmkr is the company that I work for.
Okay. So the
Yeah.
topic that we're going to touch on today is what happens when you are arrested, right?
hmm
So let's take it in the form of a story. Let's say a person is
hmm
arrested. So what happens after?
hmm All right. So basically, a person will be arrested on the grounds of the offense he has committed. Right. Nobody can be arrested without a cause.
Hmm.
If there is a cause for arrest, then it has to be whether it's a cognizable offense or a non-cognizable offense. That is, if it's a cognizable offense, it means that the police have arrested him without a warrant, that the police do not require a warrant for those cases. But if it's a non-cognizable offense, the police cannot make an arrest without a warrant.
Right.
So it depends on the intensity of the case as to when an individual and for what type of a crime
Hmm.
or an offense committed by that individual will that individual get arrested. All
So
right.
are
So
heinous
after that
crimes,
individual,
heinous crimes
yeah, yeah, no, please go on.
cognizable or non?
Heinous crimes are actually non-cognizable because they need a warrant. Warrants are given to you once evidence is presented. So you cannot make an arrest without any grounds
Right.
or an FIR. We file an FIR for the very factor that the police can get into an investigation.
Hmm.
Without an FIR, investigation will not begin. So we need to have an FIR, some sort of a basic foundation for the case to be built up. So somewhere the case has to start, whether an FIR, whether approaching the court, some sort of a legal beginning has to be there, whether direct or indirect.
Right.
So then when a person gets arrested, the person will get arrested. So we have, code of criminal procedure and we have constitution being the backbone, right? So article 22 clause 2 says that the person who is detained
Hmm.
will, be told the cause why he's detained. And after that, he's told, then he will be told that he has the right to choose any legal practitioner for his choice for his defense. Code of Criminal Procedure says
And if
for
he
a
does not
person
have
who's
the
arrested,
money to afford a
if he does not have the money, then the state will step in. If he has a choice and
right,
if he's financially sound, then it is perfectly all right for him to pay for his own advocate or lawyer or defense attorney. But if he is not
right,
financially sound and he presents it to the state, then the state shall appoint a person or prosecutor for him for his defense or a defense attorney for whatever the situation is, and the state shall bear the expenses. And this is also mentioned under article 39A, where we are provided legal aid, free legal aid, and legal aid act also exists. So all of this is encompassed legally also.
right.
So he has rights indirectly in that stream also.
Hmm.
And as far as we're talking about code of criminal procedure, section 50 subclause 2 says that if any other person rather than the accused person is arrested by the police, so the police have to tell them that he is entitled to a bail and his sureties will be handled by police themselves.
Right.
That is usually in cases when you are trying to find the accused, but somebody related to the accused we get a hold of or a lead. So we tend to arrest them to get information out of them, but they are not the accused or we don't have enough evidence against them.
Right.
So in those situations they are also arrested people, so they have rights in this area also.
Can you elaborate a little on bail?
Bail. So bail is basically like when a person is accused, they are sent to jail or prison, right? So bail is something where they get out of prison for various reasons or grounds in the same. That is, if they have good behavior, if they have completed the term, or if they have put in a bail that they have been identified for the reason that they have committed a crime or an offense which is bailable in nature. It's not non-bailable. It is not as heinous. So for example, if a person commits a robbery, okay, he does not kill anybody, he does not harm anybody, he does not threaten, he just steals for money.
Hmm.
So he is put into a jail cell, right? So now that he is in a jail cell, it is still bailable. It was not heinous in nature, it was wrong. So he is given the punishment, he understands that, so he can get out. But then there are offenses where he cannot get out, like if it's a murder, if it's a rape, or if it's any other crime which is not acceptable, it's against public morals and values, then they are non bailable offenses. He will not be granted bail.
Hmm. And after a person is arrested, the police has to inform the magistrate within 24 to 48 hours, if I'm not wrong,
Yeah,
right?
28, basically in 24 hours. He has to be presented in front of a magistrate because without which the proceedings will not go further.
Hmm.
He cannot be presented, he cannot be detained basically without being presented to the magistrate.
And what happens if the magistrate says yes, we should proceed with the trial?
Then his legal attorney, then his rights are violated. Then the legal attorney shall take action accordingly on those lines that his rights are being violated. He was supposed to be presented here, and the people who are responsible for the arrest will be held liable for the same.
Right. And if the trial
Yeah.
proceeds,
Sorry.
if the trial proceeds, that magistrate gives his go
If the
ahead.
trial proceed,
Yeah.
yeah. So if the trial proceeds, then a full, a full swing case would be there, where the arguments from both the parties would be heard. There will be a need to present the evidence, where the evidence goes on and it will be observed. That is why we need a judicial system. That is why we need a judge,
Right.
because without that, both the parties will just keep proving their points, and the case will never come to an end. We will never be able to find the true person who's the accused and the true person who's actually a victim or not, because there's a vast variety in our country where cases have been like a little dilly dally. So for that purpose we need a judicial system also.
Right.
So that is why we need this whole system where both the parties will properly go through the case. Then the judge will be observing the arguments very intricately and then giving his judgments at the end of it.
What are the two parties? One is the
Basically, we just have the plaintiff, and the one is, of course, the defendant. The one who defends himself is the defendant, and the one who feels like he is the victim, he or she, or the crime is done against them, they are the plaintiff. They are the ones who approach the court.
what if the crime happens against the state?
If the crime happens against the state, then again, the state shall take a stand for it. That is why that we've heard case laws that the state versus so and so,
Hmm.
because then it is not just against one individual, it is against the state. So the state will appoint the best of their attorneys to represent them as an individual, because that is why we have rights for a state, we have laws for a state.
Right.
So we recognize state as a legal entity.
Right.
For them also we have a advocate or whoever the state chooses to represent them in a court of law.
Hmm.
Hmm.
And in a criminal case, what percentage, if you can put it in terms of that, of evidence is required to prove that this person has committed the crime?
All right, so the standard of proof actually depends from case to case. It is not similar for every case. Like we say, we have fingerprints. Fingerprints are similar to each other, but they are totally different,
Right.
right? They will never match. Similarly, we might have similar cases, but they have intricate details which will never match,
Right.
right? For the same purpose, same punishment cannot be given to two people who have committed a similar crime, but then there are differences in the same. So when we're talking about standard of proof, that is why the judge will always observe arguments, and in such cases, the decision to give the punishment or the compensation that needs to be given is decided by the judge, depending upon the intensity of the crime committed. So yeah,
Right.
yeah.
And what is the meaning of burden of proof?
Burden of proof is that it is upon the plaintiff or the party that is reaching out to the court saying that we are the victim, this is the person who has done wrong by me, and it is their legal duty or an obligation to prove in a court of law that something that the defendant has done wrong against them. In simple terms, it is that the plaintiff's duty to present some sort of an evidence that the defendant is the true person who has done something wrong to them.
Right.
That is the basic idea behind burden of proof.
Can we talk about the admissibility of evidence and primary and secondary?
Yeah, sure. So basically, when we are talking about admissibility of an evidence, that whether they are acceptable in a court of law or not, that depends upon the court also. Like, there are many evidences which are presented. If in a criminal trial, it is not just the parties presenting the evidence, it is both the sides' arguments, then they are actually sent for testing also. There's a whole intricate procedure for the same, because the court will not reach upon a decision where the wrong person is accused for the wrong crime.
Right.
Maybe the defendant is innocent, right? Maybe he's just being framed. So the court needs to be 200% sure because we are responsible for the justice and citizens of the country. So basically, primary evidence is the one which will basically, connect the dots of the entire case.
Right.
Secondary evidence, which might come up later, which might not be the main point of attraction around which the case is revolving, but it is something which is relevant to the investigation or which connects the dots. Like, sometimes in movies, we see that, even a strand of hair can help us out, identify the person, whether it was not. It is not the main evidence, but it is something secondary, but it connects the dot that yes, this person was there. Then the investigation sets into place. So it also plays a major role. Any piece of evidence connecting the whole story, if it is the murder weapon that we are talking about, it is the primary evidence. But if it's just a DNA sample or a hair strand, which is not the main point of view, it is secondary in nature, but still it is helping us solve the case or reach a conclusion and provide justice to the person, then that is secondary evidence in simple terms.
So there's a misconception about lie detector, polygraph test. Can you elaborate on that?
All right. All right. So in Arushi case, which was a very, very famous case, what happened was that these tests were actually seek permission for. The
Right.
court had given permission, but then there was a lot of controversy on the same because there were two CBI teams. One had one opinion, the other had the other opinion. So the other one went for, all these psych tests where they could get information out with what basically happened. And these are correct to one limit, but when we're talking about a country like India, so these are not precisely admissible in a court of law.
Mm.
Sometimes, if it is applicable in the case, it is helping, then yes. But as such, they are not easily given permission for. But Arushi case was one such rare case because there was no end to the case. The case was not being closed. So they wanted to explore every option they could just to find who the actual victim was and who the actual accused was. So for that situation, in intense cases, such permissions are given. But in a normal course of action, these permissions are very hard to seek.
Let's say the police extracts a confession from a person
Mhm.
and then he denies it in court. So
All
what?
right. So basically, as far as my knowledge of law goes, that a confession in front of a police officer is not actually admissible,
Right.
right? So it has to be in front of a magistrate. Even if, there's a police officer sitting in the car and the person confesses to the same, that will not be admissible in a court of law until that person admits it right in front of an entire court of law. So that is actually very important. So the admissibility does not happen by just confessing to the police. Police are just a link between providing, taking care of that individual, detaining him, and transporting him to the court of law. So that is their basic role in the entire procedure.
And they can also coerce the accused. They can put him
No,
under.
that is actually a big misconception because that is what is shown in movies, like they'll beat them up or ask them intensely. That is not usually the case. That is actually not the case. They have to follow a procedure. They cannot hit anyone and everyone, or for a matter of fact, I think that this goes to very extreme cases where terrorism is concerned.
Hmm.
Something where so heinous that it is, responsible for a number of deaths and they have solid evidence against it. They can't be coerced. A normal petty criminal can't be coerced like that.
Right.
A proper procedure needs to be followed. They have to tell on their own. So police also has a bunch of duties and a bunch of procedures they have to follow. They can't just coerce information out of anybody. Because according to law, if we just deter from criminal law to other civil laws or anything, coercion plays a major factor in law also, in general law also. Nobody can coerce you to do anything. That is, you're being forced to do anything.
Hmm.
But when you are asked for information about police, that comes under the legal charter of their duties and the oaths they have taken. So that's a different direction. Now
Right.
we talk about, armed forces personnel. They are not liable to get arrested. They cannot just make a confession because they are protected under their duties. So it depends from duties to duties also as to whose duty is what. If they are asking, then they are, responsible for asking the victim or the person who was accused that you need to tell us if you've done something or not.
This also in Article 22 and only I believe that no person can
Mhm.
be compelled to be a witness against themselves. So what does that mean?
Mhm. So basically, it says that no individual can be compelled to be a witness against themselves. That is, if I say that I saw myself committing the crime, or if I did not see myself committing the crime, nobody will believe me.
Right.
If there is a CCTV footage of me stealing a diamond necklace and I say I didn't do it, it may be somebody else because the visuals aren't clear. But it is clear that my car was in the parking lot and I was there and I did it. Like there are all dots which are connecting to the same. So my statement will not be so liable. Everybody would want to protect themselves. Nobody would actually admit it directly that yes, I am guilty. It's human nature. It's psychologically the first instinct we have is to defend ourselves.
Right.
So to prevent that, that is why all individuals, even though we have the right to defend our country and ourselves, that is why we have advocates to do the same. We don't go defend ourselves directly until and unless we are, liable to do the same. Like if we have the legal knowledge, or we are advocates, or we are armed forces personnel in the previous cases, like Rustam's case, where he had the knowledge of law and he could represent himself. That's a totally different stream. But a normal citizen, a normal petty criminal would need somebody to represent him for the same, and his statement that I didn't do it would not be admissible. Yeah.
What are the elements or stages of crime, like mens rea, actus reus?
All right. So I would say, like, if we go into simple terms, right? If we, for the viewers who are just laymen and they don't understand these terms. So the stages of crime, if you want to break them into, that is basically crime. The main element of crime is what we focus on is that there has to be an intention. If the person has an intention, he has an idea. Hypothetically, if I was to explain this concept using an example, if we talk about somebody who wants to blow up a port,
Right.
right? So he needs to have an idea, and mere idea is not punishable.
Mm.
But he's starting to put that idea into action. In the sense, he started collecting material to form a bomb
Right.
that will blow up the port. Right now that he's forming, or he has formed a bomb, and in the meantime, leads go out and police just start suspecting and they arrest the person. Then he is a criminal, even though he did not blow the port up. Or if he did, of course, then he's a true criminal. But if he's just in the stage of preparation, he has the intention, he has the idea, and he's putting his intention and idea into a plan. He is having his way, and either he does it or he doesn't. That makes him a criminal because he's definitely treading closer and closer to his goal. So these are a few basic stages for anybody who does not have any idea what we're talking about. The first is the very idea. The second is putting that idea into plan. Third, planning it out, and then committing what he has planned. There are four basic stages if I have to divide it into what a crime is. So this is what a crime is.
There are some sections in the IPC which allow for arresting of an individual only if he has prepared or arranged something like waging war against the government or sedition. So can you elaborate on that?
All right. So basically, we have freedom to speech.
Right.
We have freedom to express ourselves. But in this situation, if we are using it to go in a negative way, if we are defaming the state, the country we live in, if we are defaming the government, we have chosen to govern us, which is not, what a lawful citizen should do. If you are choosing the government, like you have the brains, if you have the power to speak, you have the freedom to elect your government also, and you are being given a fair chance. Then speaking ill against them is obviously not acceptable in legal terms also. This is what sedition law is. So if an individual is going to that limit, because social media is the new it thing, it spreads messages like wildfire. So giving your point of view is perfectly normal. But your point of view, which is just focusing on defaming the state or the government, then it is grounds for arrest. For that very matter of fact, if it catches the eye of the government and they say like we are being presented in a bad light, we are doing so much for you, we are giving you the shelter to live in our state, we are providing you everything, we are being there for you, so why do you want to go against us? Maybe it's not the true fact, maybe everything is not disclosed to us, maybe some things are very very confidential in nature. So every human cannot just accuse the state of being wrong without having the true information or evidence. It comes back against to the whole cycle, whether we are talking about the government or the actual court of law. We cannot just do media trials on the state. So we need to have some sort of an idea as to what we are talking about. But if we speak ill or we defame, then of course it's a ground for arrest.
Basically, the idea is to prevent anarchy, right? so
Hmm.
that lawlessness does not take place in the society.
Exactly.
Yeah.
Because if everybody was to go, give their own points of view, or there was no law, like you said, a state of anarchy. If there was no law, everybody would create their own laws. There would be no uniformity. There
Right.
would be no control. Everybody
Morality
would
would
go in
be
their own
forever,
direction.
right?
Oh, yes.
Right for me.
Everybody has their own definition of being correct, right? So you can't just put them into one block or one category. That is why somebody is protesting against it, somebody is very much with it. So everybody has their own viewpoints also, but law has to be there, whether you like it or not. You all have to go in one stream where you have unanimously agreed to it. But we have to see what the majority portion wants, what is good, what is bad. Like everybody wants to become rich, but you can't rob a place.
Yeah.
Similarly, like that, somebody wants to work hard. So
Yeah.
that is exactly what you need to focus on. Like you have to work to get rich. You can't just rob a bank and be like, okay, now I'm rich, I'm settled, I'm sorted for life. So that is why you have to follow the law.
Let's go back to the trial phase, right? Suppose
Hmm.
that I'm acquitted of the crime that I was accused with in the trial itself.
Hmm.
The magistrate ordered that I'm to be released. Now, can the police arrest me again for the same crime that I was accused for?
All right. So, like, if you've been released, okay, you've been proven like there is no evidence or you weren't basically involved or anything. So, if you're released and you're like, you won't do any of this again, or even if you were totally innocent, you don't want to. But then again, if you're caught doing that, that is definitely a ground for rearrest.
Right.
Without any sort of ground or any sort of evidence, of course, you can't be arrested. You are also a citizen of the country. But if you are caught in the act again, or you are caught in any sort of act which is unlawful in nature, of course, you can be arrested again.
I was asking in terms of double jeopardy, like
No, no, not in case like you can't be acquitted of the same crime again. Like you can't, if you are, put away for something and then you are released in the trial period,
uh,
then you can't be accused of the same thing again and again. But if you're just focusing on the fact that you can be arrested again, yes, for something unlawful in nature or something similar in terms like you were caught, robbing a store, but you weren't the one who was actually robbing, you were just the one who was sitting in a car. So you were equally responsible. But the sense is that if you're caught again doing another sort of a crime, like if not robbing a store, you are on grounds for arrest again. But the same thing, you can't be arrested for the same thing over and over again unless you're obviously on a bail or a parole.
as a fresher of criminal law, when I read about 34 and 120B, it was very fascinating.
Hmm.
Like, even if you sit in a car, you can be arrested for something you are not
Hmm.
directly responsible. Like, can you
Yeah.
explain the concept in layman's term, what actually entails in them?
All right. So basically, what happens is like if you are there for your friend, or hypothetically speaking, if all of us are involved in the very idea that we want to rob an empty house,
Right.
nobody lives there, but there's a lot of expensive stuff in the house.
Hmm.
So you climb over the fence. So you plan like there are 5 people in the team. One needs to be in the car to be the getaway driver, and the rest four are the one who are going to get inside and loot the whole house.
Right.
So what happens is even though the person is not on the premises or on the field grabbing whatever stuff is available, he's still a party to it. He's still an accomplice to it because he's aware of it. He too is a part of the whole plan, and he's helping them get away rather than taking them to the police station. Right? He has an intention and he has a part in it also. So, hence, even though he's a mere driver, or hypothetically speaking of another situation, if 2 people are robbing a room and the third person is standing outside guarding, he does not know what's going on. He's just standing there. He's an accomplice to it. But the point is, he too is responsible because he did not stop them. He
Right.
did not take the lawful path. He took the unlawful path. So he's equally responsible for the act.
He's helping them execute by keeping vigilance.
Exactly.
Yeah.
Exactly. He's preventing them from any sort of action which can be taken against them.
Yeah.
So, yes, he's equally responsible.
And okay, let's suppose that the person is convicted of the crime. Then what are the
Mhm.
procedure for appeal that takes place?
All right. So, appeal is a very, very simple procedure. Okay. So, you start from the very basics. You start from the jurisdiction of the area the crime is committed. So, wherever the crime has been committed, you are supposed to go to that very court which comes or falls under its jurisdiction. So, your appealing is a system where you plead. If we go by the mere meaning of the name, appeal is to plead.
Right.
So if hypothetically speaking, the defendant is not satisfied by the judgment of a lower court,
Mm.
that is the district court, where the case is basically starting. The
Mm.
file is actually being made, everything is just coming to
Right.
take a form. So if he or she is not happy by what the judgment is, a judge's judgment cannot be questioned,
Right.
but it can be reviewed, and it can only be reviewed by a higher court.
Mm.
To do that, the defendant will take his appeal, his plead that please look into this case. I was not satisfied. I am not responsible, but please just take a look in this case. It is very important for me to prove my point. So that is where the appeal part comes in, where appeal from a lower court goes up to a higher court. So that is the procedure. And the last court to appeal is the Supreme Court. And Supreme Court's judgment is the final binding one.
But shouldn't there
Yeah.
be grounds for an appeal?
Of course, there are. There are grounds for an appeal where, okay, so what happens in an appeal is after an appeal has been made, right, the judge will look over the case. If the high court judge or the higher court, wherever you're appealing, sees that the judgment is fit, they don't find any error, they don't find like this case was, misjudged or something was lacking. That is why the defendant is not satisfied. They will not take up the case.
Right.
They will say it's a waste of time. We totally abide by the judgment, and this is the final judgment. You need to follow this,
Mm.
right? But if they feel like something is lacking or something is not correct, so they will, after a judicial review, they will take that up. They will say, fine, your appeal has been accepted, and you are more than welcome to carry the case forward, and we'll see where this case goes after this.
Mm.
So, appeal being accepted and being rejected also plays a major part.
Right. Can
Yeah.
you give your legal views on death penalty?
All right. So, capital punishment or death penalty that we say, it is not given so easily. Like you will see in movies, or the very idea, like if somebody has committed a crime, he has to go on a death row. That does not happen. Capital punishment has been a very controversial topic in our country for a while also. But capital punishment is basically death penalty given to an individual or a group of individuals who have done something very, very heinous in nature, right? But then, like if we take the Nirbhaya case,
Mm.
okay, it took a while, but there was capital punishment because there were four or five more people, like a group of people who had committed a very, very heinous crime, which
Right.
is obviously against the public morality, the values of the people, and everything, and it was totally unacceptable.
Mm.
So that is why when we have a group of people, four, five, or more,
Mm.
either a murder, whether rape, or any other crime which comes under the category of being heinous, like it's just blood curdling heinous, then we'll say that in those intense cases, we will think about capital punishment. That is why there have been controversies whether we should abolish it, whether we should keep it, because we say that laws should not intertwine with each other, but then you again have right to life, you have right to legal aid, all of them get entangled, and we don't want overshadowing of laws in the constitution either. So every concept also clashes, but it is also important. So that is why it has been a controversial topic. But if it's a heinous crime where somebody passes away because of an act of so many people, so that is the situation where capital punishment comes into play.
Right.
Yeah.
What are the justifications under the Indian Penal Code or excuses where a person can get away? I wouldn't use the word get away, but it's justified for him to.
Basically general defenses.
Yeah.
Yeah. So basically, general defenses is when the person knows, like, basic situations in IPC when the person says it's an act of God.
Yeah.
I was not responsible. If I built a house
Mm.
and it fell down because there was an earthquake, okay, I was the constructor for your house. But I won't say that even if I used cheap material and it fell down, why? Because it was an act of God. I didn't break it.
Right.
Right. So if I take a general defense, then if it comes into play that I was not willing to hit you, like it was something you were willing to accept, like when we say like it was voluntary,
Yeah.
like this goes a little off topic, but it's sort of a general of a general defense that an individual goes to watch a match,
Yeah.
right, and he agrees that there is a risk of injury, there is a total risk of injury, and in some cases in car races and everything, people have died because the cars have crashed into the areas where people sit. So in those cases, they are voluntarily agreeing to the very fact that if I sit here, I might get injured or whatever the worst case scenario being, but I willingly accept the risk, right? So these are some situations, these are some defenses, these are some general defenses the individual can take up with a matter of fact ki, theek hai, this is available to all.
Yeah.
Like if it is general, it is not like he's done some specific crime.
Right.
Specific crimes, for the very matter of fact, we have specific sections supporting the same. These are some very general in nature. Like somebody hit somebody,
Mm.
like he just slapped him. It wasn't very serious or anything.
Yeah.
We they're fighting over a parking spot, so
Yeah.
it's a crime. He hit him. It was an assault charge. But then again, why was it? It was, it was, he can take up general defenses. Like they are very general in nature from the very name. It cannot be classified into specific defenses like we do for heinous crimes. That is what any individual who has not committed something heinous or something specific can take those as a defense to prevent himself in the court of law.
Yeah. What
Yeah.
if someone is mentally incapable of understanding the nature or actions of his the act that he did, the consequences of it? So what happens to him?
All right. So if the person is a lunatic or he has no comprehension of what his consequences would be,
Yeah.
then that person is actually not responsible for the crime. Because that is something, again, if the person is of the age, he's an adult, maybe he's a 24-year-old, but he's mentally challenged.
Yeah.
He does not know what is going to happen. He does not know that if I throw a stone at somebody's head and he's an aged person, he might die,
Yeah.
right? But he does that and somebody dies. But he does not know what the action was and what its consequences could be for him. That is something very similar to a 3-year-old throwing a stone who does not know what the consequences can be, right? Even if he is an adult, he does not know his consequences and he is mentally incapable of comprehending the same, mentally also and medically speaking also. Then in those cases, they are put into safe houses like, rehab houses where they are taken care of, where their actions can be curbed, medication procedures can be given to them. But if there is a person who is, a lunatic, but in periods, that is, he is not a lunatic continuously, but for the periods in which he is sane, and if he does something in those periods, then he'll be held liable
Yeah.
because at that time he can comprehend his actions. But if otherwise, then of course he is totally insane and then he cannot be held liable.
Yeah. Okay. Life sentence is not for your whole life, right?
Yeah.
So how?
Okay, so Supreme Court says, yeah, please go on.
No, that's what I was asking.
All right. So if this Supreme Court says that nowadays life sentences are for your entire life, but that is, you will not be given bail before 14 years or 20 years of imprisonment. It is not like he won't has to spend his entire life in jail, but for these number of years, because he has committed something so heinous, sorry, that he will not be let out so easily, that he needs to be held there. So for 14 years or for 20 years, he will not be let out. So for that time, that is what we call life imprisonment, right? But in the other terms, he can be given a bail or a parole after those 14 or 20 years for a time being. Life imprisonment is not the basic idea, sorry, that the person has to stay in jail for the rest of his life.
Mm.
That is just a term which says that for a major portion, that is for quite some time, the person will not be liable or will not be given the right to get out of jail for a while. So, yeah.
There are some courts that are criminal in nature, like Tata Court or POCSO. So, but they are held to a different standard because it is a highly sensitive matter, right? Like terrorism or
Mhm.
molestation of children. So, what kind of standard of proof is held in those courts?
All right. So basically, we talk like every fingerprint is different, every case is different, all crimes are different. They
Yeah.
can be similar in nature, but they are different in their own specifications. Right. When it comes to offenses against children, it is extremely sensitive because the child will not have the ability to speak up for themselves. They don't even know what is happening against them. If we are talking about, rapes or anything against children, murders, also, like during the lockdown, we have seen an increase in the same. Like 54% there has been an increase in children's crimes. But because they don't have a voice, they don't know their rights. They are children, they are not aware of it yet. So the burden of proof or the standard of proof in these cases is high, but it is basic. ठीक है? A child is very innocent in nature. ठीक है? The child will tell you if you ask. The child is already so scared, psychologically speaking, that you have to ease the child into talking. Then the child will open up about what has happened, what is happening, this has happened. Like, hypothetically speaking, a few days ago we were just discussing about what is going on in the country and what the crimes are. So one of my family members, they told me that the children in the school were being taught about bad touch and good touch. So when they were taught about this, a girl comes up and she says, "This is what has been happening to me." So then that unraveled a whole case that his brother, the father, and one of the cousin were involved in such an activity, and it was a huge case, right? So for this, because the children are unaware of the crimes which are being committed against them, how are you supposed to explain a child directly that this is a crime? What is a crime? This would be done against you. You have to tell us. They won't comprehend that very idea. That is why we don't have punishments for children at a young age, because they don't grasp their head around the entire idea. That is why we say that crimes against children are very sensitive in nature. So the burden of proof and the standard of proof in those cases are easy to find, but yet again, since they are sensitive in nature, they are a little higher. And the same goes for terrorism. Terrorism is not a day to day activity, it's a huge, huge crime. So the burden of proof and the standard of proof is much higher than anything. Who is involved? Why are you involved? Prove that you were involved. Prove that what was your plan? Who was the person handling? Why was the person handling? Why did you attack only this spot? What all did you use to attack that very spot? So there are a number of questions that need to be answered. Why? Because the people have a right to know, to give them the correct information, and accuse the person correctly of the person responsible. You need to get to the bottom of it. So the standard and burden of proof, both of the things in these very cases go up much higher. So yeah.
We have so much to talk about. We have only 14 minutes though. So let's
All right.
yeah. Uh, okay, this is a very relevant topic. There was a controversy in a few years back, like something like you can't feed stray dogs, something like that. And also, I
Mm-hmm.
want to ask you about abuse of animals and how are they protected?
Mm-hmm. All right. So basically, animals, no, they people had the thing that street dogs can't be fed.
Yeah.
It's against law. That is not the thing. Street dogs can be fed by anybody because animals have the right to be protected. Even though they don't have a home, if they are living on the street as well, they have a right to be protected. And animals, it's a law, it's legally recognized that nothing poisonous can be given to them, nothing oily which is bad for them, which can, cause any sort of fatality can be given to them.
Chocolate frogs.
If they need, yeah, exactly. So basically, if they need protection in a rainy day or they are injured, they need if somebody is willing to help, they can help them. There is no restrictions on that individual who we are saying is totally free to
Hmm.
take care of an animal who is not able to speak. So this misconception was clarified once these animal rights came further into a brighter light,
Yeah.
where people said yes, they can be protected. We can send them off to shelters if some people are trying to threaten them, or people are uncomfortable with their presence, then we can rehabilitate them rather than hitting them or scaring them or hurting them, because they will not be taken care of by anybody. The animals don't have the right to, they can't speak up
Right.
for that very matter of fact. So animals need to be made aware in the sense that people have to take actions. Animals will not speak up, they will not comprehend what we are trying to say. We can just protect them in the way we want to offer our help. And yes, there are laws which are protecting them. They can be provided shelter, they can be provided protection, they can be provided food. Then what all is not included, what should not be given to them, they should not be hit, and all these factors, they come into play.
How many years will a person go to prison if he tortures or hits an animal?
It depends. Like, for every case, for every law that we study, there is always a range, right? There is always a range for imprisonment and the fine that is imposed. Then again, coming back to the whole procedure where we are studying law, right? So the case depends upon the nature. The nature will determine how long the case is, how intricate the case is, and for how many years would they be in imprisonment, or how many years how much amount of fine would be charged against the person. There are crime against animals also, as to speak. In cases of rape cases also, it has been so heinous. But in those cases or those situations, that imprisonment or the time period would be much longer, which would be much different.
Yeah.
But if you're just hitting them, or maybe a few months, maybe a few years, so that range varies from case to case.
Yeah. Uh, if a person is drunk or high and he's not aware of the consequences of his action, will he be punished in the
Mhm.
same manner as if he was sober, if he's sane?
If it was voluntary, it depends. Right. If he says that he was the one who got drunk, or took any substances which would alter his mind or his consciousness, or he would lose control of his consciousness, and he did something after being aware of what he was consuming will cause those consequences, this will not be the ground key, no, you are innocent.
Yeah.
But if the person was forced into that sort of an intoxication, where they were said ki, you have to drink this, nothing will happen, it's just plain water, and they don't know what's mixed with it. He was roofied. There was some sort of a crime entailing that. Then the person can definitely take a defense or action on the ground that it was involuntary intoxication and I was not responsible. I was coerced into committing something when I was not in my consciousness.
There is also this very famous maxim about this: let the man who commits the sin of drinking be responsible for the sins of his actions. Something related to
That
this.
is true.
Yeah.
All right. So basically, it means that if the individual thinks that he is responsible enough to drink,
Yeah.
so he should be responsible enough to take the actions equally, responsibly. But if not, if he commits something ill,
Hmm.
like he is not being responsible about his actions, he should know what the consequences of that entailing the same is. That is, if the person is getting drunk, he knows that he lose control of his mind and his body. Right. So whatever actions he's doing, he is aware of that.
Yeah.
That is again falling under the category of voluntary intoxication. If somebody goes out for a drink and they know they are drinking to, loosen up, lose their mind, and they'll know what will happen. They will not be aware of the consequences. Right. That is voluntary if they're doing it on their own. Involuntary is when they're not doing it on their own, they're being forced to do it. Why? Because then they are being made to commit a crime. So this maxim very well fits voluntary intoxication, where the person is getting drunk on their own will rather than being coerced by anybody else. But then they say if they are committing something ill, they then are responsible for it completely.
Right.
Then they can't take the defense of being intoxicated. This is what the basic idea of the maxim is.
Another maxim that ignorance of law is no excuse. Right.
Mhm.
And there are thousands, if not hundred thousands, of laws in our country itself. So, being a manager at a head at a publication house of laws, whereas what do you think? Like, are there some archaic laws as well which are not followed or executed by the police, or like it is no excuse itself? Like, you should be aware of them. What are your views on that?
All right. So basically, there are archaic laws. In a country where there are multiple laws, there are so many laws, but law is dynamic in nature. Law is not fixed, it
Right.
is constantly evolving. So we need to evolve with what the requirement of that moment or that generation is. You can't stay stagnant. So we have observed that there have been archaic laws, and then there are archaic laws, but some of them have been removed, right? And some of them still exist, but some of them are getting repealed because we feel like they are overshadowing, they are not needed. So that is why we keep repealing or we keep amending. That is, we don't remove the entire part, but we change some part of that law so that it is adaptable to the need of the current moment. So this is what we say, and this is what we are continuously doing. So it's an extensive research. There are a number of laws, and whatever the need be and whatever the time be, they keep just going into the cycle of being amended.
So what about this maxim of ignorance?
Okay, so we say that ignorance of law is no excuse,
Yeah.
right? If there is a law, if you are, aware of it, even though you're not, you can't take the defense that you are not aware of it. If it exists, if you're committing a crime, you are basically, and you know that it was a crime, right? You're admitting it is wrong. Then you are to be aware that there is a law to protect you. But a law will only protect you against something if there is a law which is broken,
Right.
right? This is what we say, ki if there are remedies for law, without there being remedies, a law is of no value. You have law, you have remedies for that law, because if a law gets broken, it needs to be fixed using another law.
Yeah.
Similarly, if the person is breaking a law, he cannot say that he was not aware that the law already existed.
Yeah.
Simple terms, if we say, if we are crossing a red light, if you're driving, if you're a driver, you own a car, you are very well aware that jumping a red light is punishable. So you cannot say that I was not aware of the fact. So that is useless. You need to be aware of the fact. Or you are actually aware, but you're trying to say, I didn't do it. I am not aware. Then you are trying to be your own witness, which is against not admissible in a court of law.
Right.
Yeah.
Let's end it here. Time is up.
All right. Perfect.
Very nice.
Perfect.
Okay,
Same here. I really had fun.
Yeah. I'll just stop the recording.